of TCC Judgment 112 Shenpan 8, 2023, Case on the Criminalization of Defamation. Hand notes: the TCC upheld the constitutionality of Article 311 and Article 310, paragraphs 1, 2, and 3 of the Criminal Code, ruling that they did not violate the principle of proportionality and the freedom of speech. Article 310, paragraph 3 of the Criminal Code precludes punishment if the content of a defamatory statement can be proved true. The paragraph also contains a proviso, second half of the sentence, that limits its application to statements concerning public matters. The TCC ruled that the provision is proportionate in protecting the victim's reputation and privacy. This judgment further supplemented JY interpretation number 509. In this judgment and in terms of the first half of Article 310, paragraph 3 of the Criminal Code, the TCC emphasized on the offender's duty to fact-check the defamatory statements regarding public matters, even though the offender has the objective and the reasonable grounds to believe the defamatory statement is true. Background note: Article 310, paragraphs 1, 2 of the Criminal Code stipulates that a person who makes defamatory statement may be sentenced to imprisonment for not more than 1 year. 2 years if committed by circulating writing or drawing. Shorten imprisonment or be fined for not more than $15,000, not more than $30,000 if committed by circulating writing or drawing. Article 310, paragraph 3 of the Criminal Code stipulates that defamation concerning public matters shall not be punished if the content of the defamatory statement can be proved true. Article 311 of the Criminal Code also stipulates that defamation shall not be penalized if made with bona fide intent under the following circumstances: 1. Self-defense, self-justification, or the protection of a legal interest. 2. Report made by a public official in his official capacity. 3. Fair comments on a fact subject to a public criticism. And 4. Fair report on the proceeding of a national or local assembly, court, or a public meeting. The constitutionality of this provision was previously upheld in JY interpretation number 509, where the TCC maintained that the offender need not prove that the defamatory statement is true, so long as the offender can reasonably believe it is based on the collected evidence. Petitioner of this judgment: Chang Xian-Chu, Petition 1; Yi Qian-Lu, Petition 2; Xie Jian-Xiao, Petition 3; Jun Xian-Xu, Petition 4; Yi Tian-Chen, Petition 5; Yu Wen-Lin, Petition 6; Chen Ni-Li, Petition 7; Chen Fen-Li, Petition 8 were involved respectively in cases of criminal defamation. Petitioners 1, 2, 4, 5, 7, and 8 have defamed their victims via websites, social media, or email. Petitions 3 and 6 via hard copy. The petitioners were convicted and their cases were finalized by Taiwan High Court. The petitioner each lodged constitutional complaint in the following manners: 1. All petitioners argue that Article 310, paragraphs 1, 2, and 3 of the Criminal Code, hereinafter, provision 1, 2, and 3, are unconstitutional for constraining freedom of speech disproportionately. 2. Petitions 3 and 7 argue additionally that Article 311 of the Criminal Code, hereinafter provision 4, is unconstitutional for providing insufficient justification of defenses for defamation. 3. Petitioners 1, 2, 5, 6, and 8 argue additionally for the decision of JY interpretation number 509 to be altered or supplemented. And 4. Petitioners 7 and 8 also argue that the final judgment of their respective cases, Taiwan High Court Judgment 111 Shen-Yi 720 and Judgment 111 Shen-Yi 1211, are unconstitutional. Their complaints were consolidated and argued on March 14, 2023. Summary of the judgment. Holding: 1. Article 310, paragraph 3 of the Criminal Code stipulates that Defamation concerning public matters shall not be punished if the content of the defamatory statement can be proved true. When the matter of defamation concerns public interest, which does not involve private life, that is of no public concern, even though the person cannot prove the truth of their statements. If he or she has undergone a reasonable fact-checking process before making a statement and, based on the evidence obtained, objectively believe that the statement is true, then it meets the requirement of aforementioned provision and shall not be punished. Even if the supporting evidence gathered by the person with reasonable fact-check suggests false information, the person shall not be punished so long as he or she did not knowingly or recklessly rely on such evidence. As to whether the person has met the requirements for reasonable fact-checking, it should be evaluated on a cases-by-cases basis under full consideration of the Constitution's intent to protect the right to reputation and the freedom of speech. Under the premises, the punishment of defamation under Articles 310 and 311 of the Criminal Code is proportionate under the Constitution in general, and it does not violate the protection of freedom of speech. The decision JY interpretation number 509 should be supplemented within this scope. 2. Petition from petitioner 1 to 8 are meritless and shall be dismissed. Reasoning. Principle of review. Freedom of speech is expressly protected under Article 11 of the Constitution, which includes the protection of the expression of both subjective opinions and objective facts. The right to reputation is protected under Article 22 of the Constitution. Said two rights should enjoy equal protection under the Constitution, which in principle, the state should provide its utmost guarantee. However, a conflict between these rights happens when a person infringes on another's reputation through his or her speech. In this case, the state has to primarily try to reconcile the requirement of the two fundamental rights. If reconcilable, the state has to, based on the nature of the conflict, decide on the proper balance of the interest to impose a restriction or protection toward the two rights. The standard for balancing interests should consider the many functions and the important meaning of free speech toward a democratic society and the infringement of personal reputation. In what way, to what extent, and within what scope was it infringed? In terms of providing information on public matters and communicating opinions, different speeches contribute differently based on the nature of their content and the medium. Therefore, when balancing interests between the right to reputation and the freedom of speech in individual cases, special consideration should be given to the contribution of speech to public discourse. The higher the contribution of speech to public discourse, usually the greater the degree of protection should be afforded to its freedom of speech, and consequently relative concessions should be made to the protection of the right to reputation of those referred in the speech and vice versa. Criminal provision that punish defamatory speech concerns the freedom of expression, which may only be legitimately restricted for pursuing significant constitutional rights or compelling public interest. In addition, the penal means restricting freedom of speech should be suitable for attaining its purpose. Suitabilities. It should be the least restrictive among the equal effective means necessity, and it should go through an appropriate weighing of interest to maintain a proper balance between the protection of freedom of speech and the right to reputation under the Constitution. Proportionality. In this way, the major meets the principle of proportionality enshrined in Article 23 of the Constitution. 2. Review of the court. The purpose of punishing defamation is to protect people's right to reputation, which is an important constitutional right, making the purpose constitutional and legitimate. In view of the general and specific deterrence function of criminal punishment, when the legislators choose a penal measure to punish reputation infringing offenses, the measure should aid in the protection of the right to reputation and meet the requirement of suitability under the principle of proportionality. 2. In terms of a proviso of Provision 3, the legislator did not design the constituent elements of the offense of defamation stipulated in Provision 1 and 2 based on the premises that the defamatory statement has to be false. From this perspective, the legislators choose to value the defamed person's right to reputation over the declarant's freedom of speech when it comes to defamatory statements that concern private life and not of public interest. 3. The so-called private life often involves a person's living habits, self-cultivation, value, personality, etc., which is also inseparable from the management of one's personal business. One would inevitably intrude on the referred person's zone of privacy when fact-checking statements on the person's private life. The process may even force the referred person to disclose his or her private matters to the public and engage in public debate with the declarant. If legislators intend to allow statements concerning private matters to enjoy the defense of truth, they must have a legitimate reason for limiting the privacy of the person referred to in this statement. One such reason is if the statement is related to public interest. On the contrary, if the statement is not of public interest, there are no objective justification to place the declarant's freedom of speech above the referred person's right to reputation and privacy. The proviso of the Provision 3 does not violate the requirement of proportionality under the constitutional principle of proportionality. 3. In terms of the first half of the Provision 3, the defense of truth under the first half of the Provision 3 only applies to defamatory speeches that concerns public interest. The requirement for the defense of truth should not be construed as requiring the content of speech to be objectively and absolutely true. Speeches on faith often are not issued omnisciently, especially when it comes to the media's report and the follow-up on public events, and typically when the reported events are under development. However, in a democratic society, people rely on all kinds of factual speeches of public interest to form their recognition and judgment of relevant public affairs. Provider of factual information in contemporary democratic society, no matter the media or commoners, should have some degree of fact-checking responsibility, especially for speeches that have defamatory potential. The declarants must should shoulder certain fact-checking responsibility to avoid infringing another person's right to reputation. Truth in the first half of the Provision 3 should not be limited to object and absolute truth, but should also include relative truth deduced when fact-checking. That is to say, the declarant would be exempt from punishment under the first half of the Provision 3 if his or her speech was based on the evidence gathered through a reasonable fact-checking process that can be objectively and rationally believed as true, even if the evidence gathered was not true, as much as the referencing of said evidence was not known or under reckless disregard of its falsity, actual malice. The declarant should not be punished for he or she has objectively undergone a reasonable fact-checking process. In this situation, the declarant bears the burdens of proof that he or she has fact-checked reasonably and that the evidence gathered during the process was objectively and rationally believable to be true. In cases where the material on which the declarant relied suggests false information, the burden to prove that such reliance derived from the declarant's awareness or recklessness falls on the prosecutor or the accuser. 4. In conclusion, so long as the first half of the Provision 3 is applied as such, the punishment of defamation stipulated by Provisions 1 to 4 does not violate the requirement of proportionality, consequently conforming to the constitutional principle of proportionality and the protection of freedom of speech. Within this scope of this judgment, the decision of JY interpretation number 509 should be supplemented.